Madam Chair, it's not about which party senators may or may not come from if District of Columbia were a state. It's about the Constitution. It's always what it's been about. And frankly, when we're talking about something this serious, it might be better to have more than just one hearing on the subject matter before we move to a markup. I understand and appreciate that supporters of this bill strongly believe the District of Columbia should become the 51st state. But as many of us have pointed out during the one and only hearing on this topic, there are serious constitutional as well as policy problems with this proposal. The founders intentionally crafted the Constitution so the seat of the federal government would purposefully and specifically not be within any state. As James Madison articulated in Federalist Number 43, if the capital city was situated within a state, the federal government would be subject to undue influence by that host state. Pretty common sense. These guys knew what they were doing. The bill puts the new federal enclave entirely within and subject to the influence of the new state, the state of the District of Columbia. In addition, going back to 1963, the Justice Department has consistently stated during both Republican and Democrat administrations that Congress cannot admit D.C. as a state legislatively. Here's the reason. The Constitution does not distinguish between the seat of the federal government and the district where the government is seated. The only way to overcome this problem would be to amend the Constitution. The proponents of this legislation want us to ignore that fundamental truth. In order for the district to become the 51st state, Congress needs to pass and the states need to ratify an amendment to the Constitution. However, a Gallup poll from just last year found that only 29% of Americans support D.C. statehood, meaning that this proposal stands no chance of garnering the widespread support necessary for ratifying an amendment to the Constitution. In addition to the constitutional problems with this legislation, there are equally serious policy concerns. The legislation under consideration today, and particularly the 60 pages of new text that Republicans got just 4 days ago, demonstrates the district's unpreparedness for statehood. Several of the provisions continue the federal government's requirement to fund district programs, including the new state's pension and court system, until the new state has laws in effect to provide for these services. So this bill would allow the district's special federal funding to continue indefinitely with no incentives to encourage the, quote, new state to work toward fiscal self-sufficiency. This issue deserves an honest discussion about the history that gave rise to the present situation regarding the district. In 1995, due to the financial crisis brought about by corruption and mismanagement, the federal government had to take control of the D.C. budget. No one can say with a straight face that the situation has improved to the point the district is now self-sustainable. Taxpayers nationwide, in Ohio, West Virginia, Tennessee, and Texas currently foot the bill for the district courts, its unfunded pension liabilities, and the care and custody of district prisoners. The district also receives other subsidies from federal government, including $45 million for the improvement of the D.C. public school system. But the Democrats have no interest in confronting these issues. The bill just continues to kick the can down the road. I look forward to the debate this morning, and I anticipate that we can and will offer several amendments, but I hope that in the future we can get serious about addressing some of the pressing issues facing D.C.'s finances and some of the other problems that the district has. Madam Chair, I yield back.